it'll get really stuffy in here soon.
Okay, we're on to the second of the 5 reports. That's also authored by Mr. Wesney, and that's on tangata chapter. We've got your summary statement, reasonably short, and we've got your 42A report in front of us. Yeah, I invite you to read the summary statement.
Thank you. And I'll take the first 2 paragraphs as read, and just to add lib to the summary statement, just to acknowledge, which is recorded in the section 42A report, that had advice from Leanne, the EB Partnership Manager at Marston District Council, in preparing the 42A report. So I've taken her advice in preparing that. So if needed, Leanne, maybe not, if hopefully not needed, but we'll see. The paragraph 3. The purpose and content of the Tangata Whenua chapter is based on a direction in the National Planning Standards, which states a Tangata Whenua chapter must only include context and process related provisions. Standard 6, clauses 25 to 28 of the National Planning Standards states that the Tangata Whenua chapter may contain the following content. A, recognition of hapu and iwi. Point B, Tangata Whenua, mana whenua local authority relationships. Point C, hapu and iwi planning documents. D, involvement and participation with Tangata Whenua, mana whenua. The contents of the Tangata Whenua chapter and the proposed district plan were drafted by representatives from Rangitani Wairarapa and Ngāti Kahungunu ki Wairarapa, covering the above matters within their respective sections. And I'll just acknowledge Tia and Marama to my right, representatives who were part of that process. Total of 13 submission points and 18 further submission points were received on the Tangata Whenua chapter and Appendix 1 issue acknowledgements. 2 submitters supported the inclusion and recognition of the Tangata Whenua chapter and consider it valuable to the wider community to learn and recognise Tangata Whenua's connection and ongoing occupation in the Wairarapa. Several submitters supported the inclusion of the Tangata Whenua chapter in part, but requested amendments to update the provisions to reflect the most up-to-date information from iwi, correct and clarify references, and include more diverse Māori interests across. One submitter opposed the inclusion of the Tangata Whenua chapter in part and requested an amendment to statutory relationships to ensure that statutory boards do not speak on behalf of individual owners of whenua Māori land. 5 submission points were received from Ngāti Kahungunu ki Wairarapa Development Trust, which related corrections to information from the proposed plan, more recent information needing to replace the proposed plan provisions, and amendments to clarify intent and meaning contained within the appendix. In response to the submissions received, I recommended several amendments to the Tangata Whenua chapter, including fully replacing Ngāti Kahungunu ki Wairarapa section as requested by Ngāti Kahungunu ki Wairarapa Development Trust. No pre-circulated expert evidence was received regarding the Tangata Whenua chapter. So based on the submissions, the following key matters remain in contention. So it's whether the Tangata Whenua chapter should be amended to be more inclusive of all Māori with rights and interests in place. The Tangata Whenua chapter should be amended to include hapu on, and whether the Tangata Whenua chapter in particular statutory relationships should be amended to ensure that statutory boards do not speak on behalf of individual owners in their land. So happy to take questions.
Thank you, Mr. Wesney. Just one general one from me, and it's just a point of clarification. Page 9 of your 42A report. And I just wonder whether there's a typo there in the second line, where you say that the proposed district plan addresses significant resource management issues relevant to Tangata Whenua. Would that be the operative plan?
Yeah, yes, you're correct there. Mm-hmm.
Okay. And I haven't pointed that out to be mean or anything. I did, but that highlights the quite a shift in the approach in the plan, proposed plan. The proposed plan, well, the operative plan did contain issues and policies and objectives to it.
Great.
Yeah. Whereas the proposed plan approach is really directed by what the National Planning Standards says it must and must not contain.
Correct.
And without belittling the chapter, it's more of a record and inventory of interests now, isn't it, as opposed to containing any policy direction.
Correct. But I'd add that objective and policy direction is now contained in other chapters of the proposed plan,
Such as
the strategic direction. Strategic direction chapter, which the objectives, when you compare the operative plan and proposed plan, they cover similar matters, but becomes more directive in the proposed plan, and then throughout various other chapters of the plan.
yes, such so for married purposes though.
Correct. There's one example: sites of significance, coastal environment. There's specific recognition and provision there for tangata whenua.
Yes, we skipped over the tangata whenua strategic objective that wasn't contested to any significant degree.
No.
Okay. Okay. Fine. Commissioner Hayes, do you have any questions?
I guess for me, it's a comment around the relationships around the statutory boards, and the comment around that the statutory boards don't speak. I don't know how would include that.
That's what I'm interested to hear Māori trustees' evidence on Thursday on this point, because I'm keen to, if there's a better way the proposed plan can express that, looking forward to their expertise to help with that.
But otherwise, I was happy.
Commissioner Sims, any
Kia ora. And mine's a comment as well. When reading through this, that Ngāti Kahungunu ki Wairarapa, it's been saying have drafted the section, like co-drafted. And I think as a directive, you can tell in the chapter, but I'm also interested in hearing what the submitters have on the Thursday.
Yeah.
Kia ora.
Thank you.
Yeah.
On your on the proposed changes document that we have, there's just a couple of points that I note of duplication. So in the introduction chapter, just above where you've done your track changes, you've actually repeated the first sentence. This chapter offers practical examples. So that first sentence needs to be deleted. And then again on the second page, rangatiratanga, again, that first sentence, the inherent right under Te Tiriti o Waitangi. And then this is showing that I do read stuff, Hamish. Page 16 under statutory area. Second line, marginalise the Rsness. I know. Thank you. I think that was, yeah.
But Mr. Weathy, just on that, the those duplications, are they just an error? Is it?
Formatting.
Yeah.
That's when finalising, because I can recall marking them up as being deleted when adding that new text in. So I'm not
Yeah, I thought it may have been, but I thought if I just highlight it now.
Thank you. Appreciate it.
Thank you. The one on my right, yeah,
Oh, yes,
Mr. Dixon.
Amos, I just spoke to Joe and that about this first. I think it's the wordings in the wrong way, whānau hapu, or it's referred to both ways, but what was your reply, Joe?
I said, whānau hapu.
Yes. Because we need to be consistent with it right through.
Thank you. I'll look at that across the whole document.
Yep.
In terms of that order.
Fraser? Fraser, anything? Oh, fine. No. Alistair?
No, I can't find what's going on. Come back to it.
I've got one question, Mr. Wesley, and it's in relation to one of the key matters that remain in contention, item C. C on the second page of your summary statement. Whether this chapter should be amended to ensure that statutory boards do not speak on behalf of individual owners and Whenua Maori land. Does the addition in the introduction at the last paragraph go some way to addressing that?
Yes, but that's, as I mentioned earlier, Commissioner Hayes' comment that I'm keen to hear from the Māori trustee as to whether that is sufficient or whether it needs to be changed or added to make it absolutely clear and accurate.
Yes. Respect. So that's the matter is that
It's matter 212, the office
yes.
of trustee.
Yes.
Right.
Yes, and I'll be coming at the first cab off the rank on Thursday via Teams. Nicholas Cooper and Dr. Charlotte Severn, I believe. Okay. They haven't recirculated any evidence. Well, you probably formulated a question for the panel then to that submitter. We'll go back to the Tangata Whenua strategic direction, PW 01, 02, 03 and 04. The additions that you've suggested there are primarily the addition of the words hapu and anau. And does that sort of precipitate 11B as one of the contested issues there, whether chapter should be amended to include hapu upon their wishes?
No, that's
a different issue?
Different issue. It was just fine, but
I mean, what that's doing is adding to Rangatana and Kahanunu, sending it out to other hapu and whānau, presumably.
correct.
In terms of 01, 02, 03 and 04. Which is intentional at the strategic level. I'm just wondering how that might then land in the subsequent chapters.
Yep.
Yes.
That's been.
That was a submission point from paragraph 58. It's a section 42 report on the Tangata Whenua chapter.
58.
58.
That's page 11.
Page what?
Paragraph 58.
The Tangata Whenua section 42 report.
Oh, on the Tangata Whenua report, sorry. Yep. Yes.
And sought to include this. I've used the exact words from the submission.
Yes.
Be amended to include hapu that wish to be included, as they found the chapter too heavily focused. So I wasn't 100% sure in terms of that wording, whether it was just adding reference to hapu, whether that was all they were seeking, or there was something more. So that's why I described it as a matter still in contention.
Yeah.
Mm.
Now, we're not going to hear from that submitter in person though, are we?
Not that I've been on the schedule. I may not have to be heard.
It's going to be difficult for us to test that further. Okay. What was the basis then for this, for the addition of the words into the strategic vision? Who submitted, what submission was that giving effect to? I know we're going back to the early report.
From the same submitter that I've just referred to.
Can you give me a reference?
So this is page 39 of the strategic direction for the UTO report. 38 and 39. So paragraph 263 on page 38.
Yes.
Where both Rangitani, Wairarapa and Te Tiniti, Ngāti Kahu, both sought amendments to recognise whānau and hapu in the objectives.
Yes.
So that's then been the basis of the recommendation to.
That wasn't just 01, that was all four objectives.
That was all four.
Okay.
It was a common submission point on all tanga whenua objectives in the strategic direction chapter.
Okay. Okay, well, we've got a question for the Murray trustee on day 2. Not going to hear from though any further, so.
Sorry, yeah, the submission talks about, or one of the submissions talks about sites and features that have been identified and having special qualities. Editing out that have been identified. So that's submission from Rangitani, S47-003, and it's to deal with HC02. So it was.
It's historic.
Yeah, so
Jumping back.
so yeah, sorry, it's
Wrong chapter.
I know, but it's in the first part of the report, and I missed it. It was in the Tanga Whenua part. I raised my paper the other day, and you've got accepted in part there, and I'm just interested to test that a little bit. Leading the having been identified and having taking that out opens it up quite widely, and perhaps doesn't give certainty to current landowners or future landowners. And we've spent a lot of
Can
time.
we just be clear, is that dealing with what objective, what strategic direction objective is that dealing with?
I'm looking at the submission list, it's HC02,
Okay. C02.
but it's come in as part of the first strategic directions.
It's no HC.
Just in response to that, I agree with your comment that by removing those words, it does open it wider in terms of it would include sites and areas not identified in the district plan. And the basis for that is that the district plan doesn't identify all sites of significance in areas. That's we know that there are a number of sites that haven't been identified for cultural sensitivity in terms of the centennial information. So research hasn't been done to highlight them and identify, and consultation with landowners as well hasn't been done for the focus. But this will there'll be further consideration by the panel on the sites of significance to Māori chapter later in the process, which will look at that further. The focus has been on the coast and parts of South Wairarapa rather than the Wairarapa Valley Floor, for example. So that's just acknowledging that by removing it referring it to identified, it's more inclusive than currently drafted.
Just on that, Hamish, tomorrow, one of the submitters will have that. It's in those submission. So is that the time, or are you saying we discuss that later? Both.
Who's the submitter?
I'll just
I'm with.
Yeah.
Okay, this, I think this is a pretty important issue, Mr. Wesley, so, what we will be interested in is what implications of that change to the HCO2 might have at the chapter level. Quite a shift there from identified sites to any sites that have special properties. And what I need to understand is how the policies and the rules, particularly the rules, would deal with that, particularly at a resource consent application stage. Presumably, there's a method or a rule for dealing with that in terms of sites that have been identified in the schedules. But any news, how that's dealt with for any sites that's not dealt with in the schedules, something that the panel needs to understand.
Just flag for your relevant or for information now that the site of significance to Māori chapter and the objectives in that chapter, that's not limited to identified ones. It's similar to wording what recommended in the strategic direction. It's all encompassing.
Okay, so could this be categorised as a bottom up change to the strategic objective as opposed to a top down?
No, it's responding from my perspective, just responding to the submission on that, where it's seeking the or a questioned whether by limiting it to identified, whether that was too narrow. And so to me, rather than the bottom up, it's making the plan consistent across the chapters rather than potentially inconsistent now.
Okay, I think you're going to have to spell that out in your right reply, because if the strategic direction was initially those sites that have been identified, but these sites of significance to Māori chapter takes a broader view, then that indicates that there's an inconsistency between the strategic objective and the objective and the plan that's notified. So whether, and giving effect to that submission as you've recommended, is that rectifying that inconsistency? And if so, how is that dealt with in the rules? Were there any further submissions in support or opposition to that submission? Saw that change?
No, not that I read, David. No.
Okay. That's something to add to your list of homework. Thank you.
What was there for that?
And that's, no, we're chopping and changing between the reports there, Mr. Wesley, but that just shows the integrated nature of the plan. I don't have any further questions on this chapter. That presumably now takes us to the procedural matters.
Also myself. And I have no summary statements for this because there's nothing, I think, new or different than what was contained in the procedural matters report.
Let me just get to that. Reasonably short report too. Want to just talk to the high level, or do you want to read?
No, I'll just put in a summary format if that's. Section. So the purpose of the report is two procedural issues that have come up with the further submissions that have been received on the proposed plan. The hearing panel might recall, as the committee previously, there was some late submissions on the original submissions that were received after the closing date, and that's within the committee's jurisdiction and now the hearing panel's jurisdiction to waive requirements to comply with the timeframes. So this is a report of a similar nature in terms of the further submissions that were received late. So that's what's set out in section 2, so paragraphs 15 to 18. Here with, let's find a list. 8 further submissions that were late. Those 8 further submissions were all no longer than 1 day late from the deadline. A couple of them one was due to illness, one was due to an IT issue, unknown why the other ones were late, but they were received shortly after the closing date. And we've assessed the implications of those late submissions, including them in the process. And as summarised in paragraph 19, to us, there's no reason why you wouldn't accept them into the process. So that's a decision the panel will need to make as to whether you accept those 8 late submissions listed in Appendix 1 into the process.
We we'll probably make a decision on that properly, I think.
Yep.
Particularly if it because it'll affect the attendance of those further submitters at subsequent hearings.
Correct.
Have you, sorry, I should know this, have you listed those 8 submitters?
So they're Appendix 1.
Oh, sorry. Yes, got them. Okay.
And then the second matter are some further submissions that were received, missing some information. So Form 6 of the forms regulations for the RMA set out what information is to be submitted in a further submission. And as listed in Appendix 2, there was some information that was missing from some of the further submitters, which enabled in the majority of cases to be able to clarify with the further submitter what that missing information is in the document. But the other matter with further submitters is that there's a limitation in the RMA on who can be a further submission.
Yes.
Further submitter. So in paragraph 20 in the report, I've listed the 3 criteria for being a further submitter, being a person who is representing a relevant aspect of public interest, or a person who has an interest in the proposal greater than that of the general public, or thirdly, it's a local authority. And there are 4, in our assessment, there's further submitters who haven't completed which one of those categories they fall in, and given us reasons for why they fit one of those categories.
Yes, I can see that.
We've gone back to those 4 people and asked them to advise us which of those categories they fall within and the reasons why, and they haven't responded to at this point still. So we're in a bit of a dilemma as to what to do in terms of their non-responsiveness to confirm they are one of those categories. And we know that the councils have been taking a very open and inclusive approach to date, and that's informed our evaluation approach with them, is trying to include them into the process. But we need to, from a technical legal perspective, we need to know that they are appropriately have one of those statuses to do it. So if the committee or the panel's happy, we'll continue to contact those parties and find out,
Yes.
their reasons, and then report that back.
If you could, and if you could, with saving us doing a minute on it, you could say that the panel is directed you to ask Submitter Pedersen, Headley, McGuinness and Gunn to furnish that information so that we can make in a timely manner. So, we'd really want that. We'd certainly want that before you write a reply, so that you can then finalise that. So I think we have that in the next 10 working days.
Mm-hmm.
And I guess in the absence of that, we'll need to make the appropriate decision.
David, if they miss a chapter though, we can't go back to it because of late thing.
No, but
submitting on a particular chapter.
this is not just that this is not in relation to lateness. This is in relation to what Mr. Wesley's saying is that the ability to lodge a further submission is now constrained to having meeting certain requirements set out in the Act. It's not an open slather process like it used to be. So all further submitters have has spoken to those reasons as to why they qualify as a further submitter, with the exception of those 4. And to be in the tent as a further submitter, they really need to comply with the requirements of the Act.
Just for the panel's benefit, we've included those 4 in the list of submitters and the evaluation of the submission.
Yes.
So, for example, Ian Gunn, he's included in this. Really? So that's so if there's no response from Mr. Gunn, then we will obviously advise that in the right of reply, and then you'll have to make a decision on what to do regarding his status.
Sure.
And then if you decide that he does not have status as a further submitter, then you'll need to make that decision, and then you would remove him from any reference in your strategic direction decision.
Yes, so I think the process is they need to respond within the next 10 working days, and you need to incorporate that response into your right of reply. So they're really just the 2 procedural matters, the lateness and the reason.
Just the last thing to note, paragraph 13 on page, is on page 2, it's unnumbered. Just to note that there's been 2 submissions that have been withdrawn.
I see that.
Just to bring that to your attention.
All right, Adrian Young Cooper and the Aviation Industry Association.
Correct.
Okay.
But there's no procedural.
No.
As we'll just remove them from the list in future reports.
Yes. And from the tables. Yes.
Yeah.
Thank you. Panel, any questions about procedural matters?
No.
Mr. Webb, you can take a break now. And Katie, the whole of the plan.
Oh, thank you. The whole reason.
Welcome, Mr. Redaway. Good time the panel's had your attendance person. I take it from that your involvement in the plan and the preparation of the plan has been reasonably limited.
Yeah, it's mainly been limited to some specific chapters, and probably since the start of last year, so 2000. Yeah. So some things I have a bit of knowledge on, but
Yes.
much as Mr. West.
And where you don't know an answer, that's the right answer. And we can delve down on how to deal with those matters. So don't feel obliged to manufacture an answer if you feel you just don't have it at your fingertips. Okay, can I just invite you then to take us through your written statement, and then we'll see what questions we can.
Thank you. I'll take the first 2 paragraphs as read. But the purpose of and content of the whole plan topic is to respond to the submissions on the whole plan that are general or miscellaneous in nature and do not fit in a zone or district-wide matter chapter. A total of 44 submissions, 6 original submissions, 63 submission points, and 15 further submissions, 65 further submission points were received on the whole plan topic. And these submissions fit into the following key issues: tangata whenua, orders, general corrections or clarifications, miscellaneous matters, submissions and support matters outside the scope of the district plan review. In paragraph 5, I set out the changes that I've recommended. and they're summarised in the bullet points. I do note that in bullet point 1, there is a minor typo. There's a comma between mana and whenua in the first line. It's just meant to be mana whenua. So you can pick that one up.
Sorry, I missed that one.
And so the first bullet point is a comma in the wrong place, or not meant to be included.
Spell check doesn't help with those.
I've read the evidence of Greater Wellington Regional Council, Miss Zollner, and also the legal submissions from Wellington.
Thank you.
Greater Wellington have made a submission seeking that a Three Waters chapter is inserted into the proposed district plan, and several submitters have made further submissions of this. Businesses, Energy and Transcar have made a further submission in opposition. This statement is mainly going to focus on the evidence from Ms. Zollner, which is structured into 4 parts, and that's set out in paragraph 9. And so I'm going to respond to each of those matters. So paragraph 11, as set out in my section 42A report, there is scope for district councils to give effect to mana tuai in terms of high-level direction to consider water bodies. I consider that the provisions of the PDP achieve this, and the PDP also gives effect to the National Policy Statement for Freshwater and the Operative Regional Policy Statement. So provisions NE 05 and 02, subdivision 02 and P2, and the development standards SUB S3, 4 and 5, an example of this. Wesley referred to some of these. In my opinion, the provisions provided by Ms. Zollner are more within the ambit of the Regional Council. These sections of the RMA. I acknowledge the evidence that Ms. Zollner received from Ms. Zollner. My opinion has not changed, and I do not consider a Three Waters chapter is required. So in Appendix 1 of my summary statement, I've identified the existing direction in B that relates to Three Waters or fresh water. And I note that these provisions include additional standards and those provided by Ms. Zollner in attachment 2 of the evidence. I consider that the existing provisions in the PDP, along with the Council Engineering Development Standard, are sufficient in managing Three Waters in the Wairarapa. I also note that Ms. Zollner has not provided a Section 32AA evaluation of the provisions sought in their evidence, and their evaluation and limited evaluation of the benefits and costs of the provisions sought. Therefore, as set out in my 42A report, I consider the Three Waters chapter is not required. Where relevant, this direction is set out in the subdivision and zone chapters. So paragraph 18, I've reviewed the amended provisions provided by Zollner, specifically the rules relating to stormwater management. Given the context of the Wairarapa, which is less densely developed and has more capacity for groundwater soakage, I do not consider these rules are required. And as already noted, I consider that these rules were within the ambit of the Regional Council. Hydraulic neutrality, I think this is less applicable in the Wairarapa context due to its lower density of development compared with other districts in the Wellington region and the higher capacity for soakage. Wairarapa has significantly less impermeable surface area and therefore relies more on groundwater soakage to manage stormwater than engineered solutions. Therefore, I do not consider that the amended rules provided by Ms. Zollner are necessary. As set out in my 42A report, the current PDB approach of the development standards in the subdivision and zone chapters and the Council Engineering Development Standard allow for hydraulic to be determined at the time of resource consent by Council's development engineers. So based on the matters raised in the submissions and the pre-circulated expert evidence, I do not recommend any changes to the evaluation or recommendations in my section 42A report.
Okay, I'm happy to pick off again, if anyone's got some burning question. Straight away, I think, there's a real relationship between, this topic and particularly, issue 2. Free water, and that seems to be the most contested of the whole of the plan matters. The relationship between that and the discussion I had with Mr. Wesney, regarding giving effect to the MPSFM and Mana O2Y. And the matter's highly contested. We've got the plan is notified, which does not contain a Three Waters chapter and does not contain a specific to Mana O2Y strategic objective. We've got the submission from Greater Wellington that's saying that the plan as notified doesn't give effect to the MPSFM for a variety of reasons, including the absence of a strategic objective, which addresses prioritisation, but also because it doesn't contain a Three Waters chapter. We've got submissions primarily from Meridian and Genesis opposing the Greater Wellington position, and particularly in relation to Genesis, saying that provisions lack clarity. We've got and then we've got your summary statement, which, having considered all of those matters, hasn't recommended any further changes, which is similar to Mr. Wesney's position, and not recommending a strategic objective to deal with O2. So that creates a bit of a quandary for the panel. We've got a highly contested issue here, and we'll obviously benefit from hearing from Ms. Solner on Thursday. But in the meantime, I just want to test a couple of the matters with you. And particularly Ms. Solner's critique of your report, starting at page 26 of her evidence of chief, on page 9. And Ms. Solner says that that you are making 2 points, that territorial authorities do not have a role in regulating the matters sought by Greater Wellington. And secondly, that that Greater Wellington has proposed is confusing or creates duplication in the structure of the plan. So just deal with those 2 points initially. Do you still maintain that territorial authorities don't have a role in regulating the matters sought by Greater Wellington, or is it more nuanced than that? What the role in giving effect to the MPSFM might lie principally with the regional councils in terms of their Section 30 function. Would you accept that the district councils do have a residual role in terms of their functions under Section 31 and avoiding, mitigating and remedying any effects on water bodies?
I would say they have some role in terms of how it relates to subdivision and urban development, but that would be covered in, I guess, the subdivision or zone chapters.
So that, would you go as far to say that that role is limited only to subdivision and urban development?
If I consider.
What about, and I'm just testing these, what about earthworks provisions? Is there a role there for the district council in terms of the effects of earthworks on water bodies, or is that a function that rests elsewhere?
I would have thought that that would rest with the regional council. Yeah.
In terms of, accepting that there is a residual role around, in your opinion at least, subdivision and urban development, question for us is, how do are the provisions that are in the proposed plan appropriate to deal with that residual role, having regard to the need to give effect to the MPSFM and the operative RPS and the have regard to the proposed RPS. You've listed in Appendix 1 the provisions that are in the plan as notified. And I think Ms. Donna's also got those in her evidence also. Double check that I'm not.
Yeah, I think they're in
Yeah.
catchments.
Yes. Yes. Can you point to any of those provisions that deal with that integrated approach in terms of subdivision and urban development and the direction that they provide?
I mean, you've got sub O2, which is the objective and particularly B, so making sure the wastewater, stormwater and water measures provided. So in those three waters measures. And it also talks about avoiding adverse effect. And then there is also specific standards in the subdivision chapter on drinking water supply, wastewater disposal.
Would it be fair to say that the majority of those provisions are focused on ensuring that there's sufficient servicing capacity and feasibility?
Yes, I would say that because a lot of the standards in the next own chapters.
Yes, I'm looking at
Drinking
drinking water supply, wastewater.
they're sort of repeated a lot.
Yes.
Yeah.
And that takes us back to the front end of these provisions in the appendix, NEO2, NEO5. And I pointed us to subdivision O2, which does talk about the avoidance, remedy and mitigating of the effects on the environment. But that's qualified, isn't it? It's avoiding the effects on the environment by ensuring that subdivisions are connected and have available capacity and are capable of being serviced. It's almost on a technical matter as opposed to an effect on the environment. Well, I'm not trying to put words in your mouth. Would you agree with that?
Yeah, I would agree. Yeah.
Would those provisions be altered to better or more, or the term is more appropriately address the spirit of the MPSFM and the RPS?
They could potentially, yes. It would be interesting to hear the evidence on
Yes.
As to what might be appropriate in altering them.
Yes.
Yeah.
Because your method, you're quite dismissive of the need for a standalone chapter.
Yeah.
You're saying that the provisions are there, albeit that they're a mix of strategic direction objectives, subdivision policies and standards, and the odd like the general rural zone standard. What else? That's probably it. Those are the three. I guess what I'm not explaining very well is whether that is the most appropriate integrated approach to dealing with what you accept as a residual function for the district councils in terms of giving effect to the MPSFM.
Yeah, I think they could certainly be altered rather than there being a whole new chapter.
Yes. And would there be scope to do that within the submissions sought by
I believe
Greater Wellington?
there would, yeah.
Yes. And I acknowledge that Genesis and Meridian would be interested in that also, given their further submissions. Okay. Well, we'll have questions for Greater Wellington and Genesis, and we won't for Genesis, but I'm not attending that. Certainly, Ms. Foster, Meridian. Okay. The second matter that Ms. Sona raised, and I'm going back to her evidence. Where I was. Oh, yes, page 9, paragraph 26. Dealt with the role second concern that you'd raised and that she took issue was that the provisions as requested in the submission are confusing or creates duplication within the existing structure. Now, Ms. Saunders attempted to respond to that, and she produced a track change version, which is colour coded purple, and it's a mixture of additions, modifications, and deletions. First question to you is, does that resolve any of your concerns about the confusion or duplications?
I think some of the perhaps confusion of how the chapter was going to sit are resolved in terms of particularly the introduction. But there is still maybe some duplication in it than the plan elsewhere.
Yes.
Yeah.
Are the changes that, in your view, that Ms. Saunders recommended within scope of Greater Wellington's original submission?
I believe they would be, yes.
The reason I asked that
Yeah.
is there are, apart from the deletions
Yeah.
and tweaks, there are two additions proposed. That's the addition to the introduction, and I think there was a new definition of hydraulic neutrality being proposed, which presumably weren't requested in the original notice of submission.
Yeah.
Could I invite you to reflect on those two matters, conjunct with Mr. Wesney, and we will assist you in that by asking questions for Greater Wellington on Thursday.
Clarification, so you're saying they weren't in the originals?
On a plain reading of the appendix Saunders provided, it looks like any additions or amendments from the original submission is shown in purple. So I've just taken that as those were two additions, whereas she has replaced Rule 1, Rule 2, Rule 3, and Rule 4 that were in the original submission. So she's shown those as crossing out and replace those other provisions she's tweaked. Yeah, but that two that stood out as potentially raising the question as to whether they were within scope or not. I guess just to try to summarise all of that, I think there's a role for you and Mr. Wesney at your right of replies to look at whether there may be I don't want to call it a middle ground, but whether in terms of the appropriateness test, whether there's a role for some reflection of the council's residual responsibilities at the strategic direction level. And to promote integration of these provisions that are set in at least 3 different chapters of the plan, and how that might be achieved. And there may be a role for you and Mr. Wesney to sit down with Ms. Solner after Thursday to work through how that might be achieved on a without prejudice basis. And I'll suggest that to Ms. Solner on Thursday. Hey, I didn't have any further. Oh, sorry, I did. But was there any further questions from the panel on the 3 waters chapter, which seems to be the main issue arising on this topic? Joe, no. Robin, Alistair?
I'm interested to hear.
Yes.
Yeah.
Okay. I have one final question. It's about the topic of hydraulic neutrality. Your paragraph 21 of your summary statement, you start off in paragraph 20 saying it's less applicable in the Wairarapa context due to its lower density of development, but Ms. Solner takes issue with that by saying, well, some of the provisions will allow for increased intensity and of urban development, and that will come with an increased pervious surfaces and ability for greater extent of runoff, either from hard stand surfaces or from roof catchments, that sort of thing. So she's querying the applicability of the concept. She's saying that she's querying your understanding of the applicability. Notwithstanding that, you say that the subdivision zone chapters and the engineering standard allow for hydraulic neutrality to be determined at the time that resource consent by council development. Are you in a position to explain how that would work on a case by case basis?
So it would be more of at the time of a resource consent, if there were consent conditions,
Yes.
the council development engineer would have input into those.
Yes.
And at that case, there may be appropriate conditions that are placed on.
Okay.
That's how I see it working.
Is there is hydraulic neutrality or an equivalent term matters of control or discretion on resource consents? Is it something that the council can address their mind to?
There is matters, I'd have to double check, but in the standards, it does refer to the council development engineering standard. I'm pretty sure it's in there. And that talks about, within the standard, it addresses stormwater. I would say they could address it then.
It would be useful if you could outline those in your right of reply. That covers off where a resource consent is required. What about where a resource consent is not required? The activity is permitted, and there will be several developments that are permitted. And what's the mechanism for testing hydraulic neutrality on a case by case basis? In that case, if it doesn't trigger the need for a resource consent.
Yeah, that's something I should cover. Yeah.
Okay. Does the engineering standard have a role at the building consent stage? Was that too late? That's all from me. Checking. Oh, yeah. You missed straight away. That's very useful. Oh, we're making very good progress. Takes us to part one of Robertson. But we'll be adjourning early for the day, so we won't take a adjournment. And we'll work through it until we've completed it. If there's any objection to that?
No,
Good to hear.
definitely not. You got my handouts on?
Yeah, here it comes.
Oh, there you go. Oh, yeah.
Thanks, you.
Right, morning, Ms. Robertson. What you do, take us through your summary statement, please.
Thank you, Mr. Chair, Commissioners. Section 1 sets out a little bit about me and the fact that I'm the reporting officer for this chapter. You'll note in part bullet point 4 that part 1 has been developed in accordance with the national planning standards, which direct how the district plan is set out. The chapter includes your general provisions, your frameworks, your national direction. It includes a forward by the 3 Wairarapa mayors. Throughout the process, we received 18 submissions and 19 further submissions were received on part 1. The majority of the submissions were in support and only 2 were in opposition. Throughout the analysis of the submissions, we have broken them down into 3 issues, one being the mihi section on how the plan works, the introduction section, with the mihi, issue 2 being how the plan works, including your statutory context, general approach, and the relationship between the spatial layers, and then issue 3 being national direction instruments, including the national policy statements and the national environment. You all have my section 42 report with recommended changes. So as such, with my hearing introductory statement, I have very much just responded to the pre-circulated expert evidence and focused on matters of contention or areas that we wish to change. And I'd just like to draw your attention to an incorrect statement in my 42 report, which I have covered in point 12 of my introductory statement, which was the correct reference for Meridian. And then in point 16 of my summary statement, underlined in bold is an addition that was agreed in the section 42 report, however, was admitted from the final document. So the main issues in contention, and this does reference back to Mr. Wesney's earlier one with the strategic direction and the hierarchy, is that Ms. Ng, on behalf of Transpower, generally support the direction that the plan is taking, but they were in the part 1 requesting just further clarification around the hierarchy and that there is no fixed hierarchy between your strategic objectives and the other objectives and policies in the plan. In the 42 report, you will note that I have recommended that that doesn't be adopted because I believe you can start duplicating too many things within a plan and make it more confusing for the reader. And it does sit better within that strategic objectives by outlining that there is not the hierarchy. And then the other matter that probably needs a little bit more consideration that has not been resolved is the Transpower request in relation to cross-boundary matters. And again, I have recommended that we haven't done a change from a plan perspective. I think having a combined plan demonstrates quite well that you do have some cross-boundary matters working with the 3 territorial authorities. I'm not aware of issues arising over the life of the previous plan in relation to cross-boundary matters. I've gained clarity. I don't believe it needs to be added. However, I also would not be opposed if that was a matter that the panel or Transpower elaborated on.
It's a very concise summary. Thank you for that. I've got one question, and it does relate to the cross-boundary matter. Thank you for telling us why your recommendation is not to include it. If the panel was of a mind to include it, you wouldn't be opposed to it. The wording that's been provided by Transpower, if the panel was of a mind to include it, are there any changes you would think to make to the wording?
No, I believe the wording is broad enough that it's not just relevant to your electricity networks, it is all the linear networks, including roading and transport.
Not trying to pick a winner, is it?
No.
It applies in an even-handed way to all. And presumably accept that if there was a case to be made for a cross-boundary inclusion, linear networks would be one of the first cabs off the rank, and that's it.
Absolutely.
Okay, have a second question, Ms. Robertson, and that is the strategic direction hierarchy. You would have heard my question, Mr. Wesney, earlier, that there's no hierarchy between the strategic objectives. And whilst there's no explicit hierarchy between those and the objectives that sit in the subsequent chapters, seems that the second sentence in the proposed plan, that all other objectives and policies should be read and achieved in a manner consistent with the objectives, would imply that there is some sort of hierarchy between the objectives and the chapter objectives. Do you agree with that or not? On a plain reading of that second.
On plain reading, you could understand that to be the case.
What's your understanding of the term should be read and achieved in a manner consistent with the objectives? Doesn't that suggest that the goal state, we've heard from Mr. Wesney that the strategic objective, direction objectives are a statement of outcome, goal, if you like. Aren't the objectives and policies that sit below those in the chapters, in terms of the words should be read and achieved, aren't they in effect trying to give effect to those strategic objectives?
It means to achieve the goal of the strategic objective as a goal.
Yeah. And doesn't that imply some sort of hierarchy that the strategic direction objectives are sitting high, and that the objectives need to be written and in a manner and it is consistent with those objectives and achieve those objectives? Doesn't it suggest a bottom-up achievement? I don't want to be putting words in your mouth.
I'm just having a think about that, and in particular how it is relating to the part one topic.
Yes.
Because the strategic direction being its chapter, and how that request in this part was linking into the part one.
Yes.
Um,
Certainly missing when Transpower prepared the submission, had some concerns about the relationship between the strategic direction objectives and all other objectives in the plan, and that led her to seek that to acknowledge that there's no fixed hierarchy between the strategic objectives themselves or between those objectives and the other objectives. Now, you recommended deletion or not acceptance of her relief and reliance on the text that was in the notified version. And all I'm putting to you is that the second sentence of that notified text in the proposed plan implies that there might be some sort of hierarchy. And was that the intention? And
I don't believe that was the intention of the plan when it was written, because it does clearly state in that first sentence that there is no hierarchy between them.
Or in the wording
yeah,
of that second sentence.
well, certainly the first sentence makes it very clear that there is no hierarchy between the 7 categories of strategic direction objectives. But the second sentence indicates that there might be some functional relationship between the strategic objectives that sit in chapter 2 or whatever it is and the other chapter objectives. So I'm happy for you to reflect on that and maybe with the assistance of Mr. Wesney address that. But your recommendation at this stage in any event is to rely on the notified version and not to make the change requested by missing.
Yes.
Thank you. Okay. Anything else, panel? Nothing, on the end? Right. Thank you for that. That's good. Okay, and I think, so up on the final matter on interpretation. So, Where, that's one, there's been,
Last one for the day, Freddie.
it's
You get a lot more. It's a definition, isn't it? Thursday night.
okay, we've got your summary statement in front of us. Happy to read it or just take us through the main points, your discretion.
Probably. Thank you, Mr. Chair. I will read through the bulk of it, but there will be parts that I don't need to elaborate on. And so I'll just start with number 4. So 21 original submissions with 52 submission points were received, 12 further submissions and 28 further submission points. I've made it clear in both my 42 report and my introductory statement that the definitions that were being addressed through this report were those that had all of plan interpretation. So they were specific to a zone. They've been picked up by the zone authors in later hearing streams. Out of those ones that were relating to all of plan, you will note that there were, ended up grouping them into 7 issues as it was the most appropriate way to deal with the individual requests. And I just want to note that I'll jump onto issue 5, and I've touched on it in my report. The definition of community facility in my 42A report, we recommended amending the definition to include the note that it specifically includes land and buildings used for emergency services. This was requested by Foreign Emergency New Zealand, and it seemed logical. However, actually going through and doing the summary evidence and statement and re-going back over the plan, I inadvertently noted that this is a National Planning Standard definition and I don't have any ability to amend.
Yeah.
So I consequently no longer recommend any amendment to that definition. And we also did receive a letter from the Department of Conservation the other day just requesting a clarification omission point on their original submission. Their submission was they were in support of the definitions, except for where they have requested specific changes. Most of the changes that they have requested to definitions will be picked up in hearing stream 2 as they're relating to the open space zone. So that has been just clarified with their submission. Otherwise, it could have been misleading to anybody reading it that Department of Conservation were 100% of everything.
On the definition of community facility and the exclusion or otherwise of emergency services facilities, you haven't addressed it in your summary, have you? You're revising us now verbally, aren't you?
Point 13 on the summary.
Oh,
On the summary. Oh, you're on the wrong one. On the time.
wrong one. Okay. Okay,
So you're withdrawing 6.7 in your 42 report.
And just noting that emergency services define themselves as a national planning standard, so
is, so what's the outcome of that? Emergency services, facilities are a community facility, but they're also defined in their own right.
I think if they're defined in their own right, by default, they then should be excluded from community facilities in a pure interpretation
Yes.
matter.
Yes.
And I
That you don't have the ability.
you don't have the ability to specifically, which is what Fens were requesting. And it did seem suitable at the time. It's unfortunate we can't clarify that.
It's a bit of a, that's for plan users and readers, doesn't it? Okay, I guess you're relying on the more specific provision applying more specific provision, in this case, it's emergency services provisions, which has its own definition in the plan.
Yes,
Is it a national planning?
that is a national planning standard definition.
Wow, it's interesting. You're potentially an inherent conflict within the national planning standards, but will there be zones in which community facilities and emergency service facilities have different activity statuses? Could you identify those in a table for us in your right of reply?
Certainly.
We need any legal advice on this matter?
Can I look into that and get back to you?
Yeah. Fans won't be aware of this issue, or have you had an opportunity to discuss it with them? Because they're not proposing to attend this hearing stream, are they?
No, they're not.
Would-
They are a submitter in hearing stream 2 with similar
It's open space.
industrial zone.
Okay. Could you contact them and just let them know how you've arrived at your paragraph 13 in your summary statement? And I'm happy for them, out of fairness, to table a document they don't need to attend. Just responding to that. Maybe advise them of the exercise that I've asked you to do. I just want to get a feeling for their response to that issue, so that they're not feeling that they're sort of broadsided, if you like. Represented by Becca, I believe, are they?
I will contact their representative.
Yes. Don't really want to leave it to hearing stream 2 to resolve, but really want them to respond within 10 working days, so that you're able to reflect that response in your right of reply. Okay, now, how do you want to deal with the other matters?
Can I just make one correction? Just
Sure.
jumped on. The emergency services is not a national planning standard definition. It
Okay.
is, so that could be a potential tidy up using that definition to clarify.
Maybe it's time for the national planning standards to be revisited. They're probably about 4 years old now, I think, 5 years.
So you'll note, I've just addressed the issue 5. Issue 4 was the national planning standards definitions that were accepted. I just wanted them listed in the plan for the panel to note. Same with the statutory agencies. The main ones that were issue 7, noxious and offensive, was very much a clarification and a numbering change, because how it was written in the plan, it was alluding that the other activities were potentially subordinate to the main one. That was not the intention. So that is very much just a tidy up. And then that's also just clarifying other activities that can fit within the realms of noxious and offensive, excluding municipal recycling and processing facilities, as recycling should not be a noxious or offensive activity, and if it became noxious or offensive, there would certainly be other rules that would be triggered requiring potentially resource consents. One of the main issues that came out was, in particular, reverse sensitivity. There was a lot of submission points on that with varying different proposals of the most suitable wording, and you will note that after analysing the wording, what was proposed by Kiwi Rail appeared to encompass a lot of what we could foresee in the future and was a lot more broader. So as such, it was my recommendation that the definition by Kiwi Rail was accepted for reverse sensitivity. The further submissions after the section 42, the evidence that came out, there wasn't a single submitter group that then opposed that definition of Kiwi Rail. So
this is a brand new definition that would be inserted as a result of submission.
we did have a definition of reverse sensitivity in the draft plan that went out.
Why was that deleted?
It was determined that there was enough references in other parts of the plan relating to reverse sensitivity that it should have been covered. And then when submissions closed with a number of submitters requesting it being defined, and then looking at where it was in the plan, it made sense from a planning perspective that if you're going to use a term in a plan, particularly something like reverse sensitivity, that it would be useful to define it.
Yes. My memory's not the greatest, but I'm aware that the Environment Court have addressed the issue of reverse sensitivity and its definition in the past. Can't give you any citation on that, but and I know that I've had submitters quote that definition in hearings, and I just wondered how that definition compares to the Kiwi Rail definition. Is it similar or the same? I'm going to have to ask you to do a bit of homework to dig out that. I can't give you the citation, sorry.
No, I will dig that out and address any comparison points.
That would be really useful.
The Kiwi Rail definition is similar to what has been adopted by Wellington City Council with similar arguments, and given that was a recent plan.
Sort of familiar with that plan, yes.
And then the main one I just want to start addressing is the surface water body, which has turned into quite a
Well, you'll have a few questions
matter.
on the panel on that. I know when I was involved in the post-natural resource plan for Greater Wellington, a significant issue.
Yes, and Horticulture New Zealand are still recommending that the race and artificial channels are removed from that definition. They're not requesting the definition itself be deleted. They are recommending that those two terms are removed. And I have in my section 42 a report tried to talk about the Wairarapa context and why, from a planning point of view, I believe it is relevant to include those terms.
Your paragraph 136 captures that.
And you'll note in the appendix 1 to my statement of evidence, I've gone through the plan itself and listed all the provisions where the term surface water body is noted, and that's primarily, when you look at them, it is very much around managing setbacks from water races, artificial channels, rivers, streams.
Can I just ask a question which might be useful for the recording, and for anyone watching this subsequently? Can you give us an indication of how many kilometres there are of water races in the Wairarapa? Silence.
Hundreds of.
306 and.
Yeah.
Yeah,
Okay.
I
actually.
have to say, I potentially did anticipate that when I used a broad statement of there is hundreds of kilometres of water races. So Maroa is 240 k's, Longwood 31, Taratahi 320, Carrington 180 and Opaki 23. So it's about 616 kilometres of water races, which when I did a quick calculation earlier is the exact distance from Carlton Event Centre to Queen Street in Auckland.
You replicate that in your
perspective.
you replicate those numbers in your reply, please, so we've got them as part of the record.
I knew it was a lot, but when you put it into context of Carterton to Queen Street, that's.
Yeah, very significant.
Thank you.
And it's very much on that basis of the number of the water races, which is why I'm not recommending any amendment be made to my section 42 report. I also do note in my statement of evidence that, yes, water races and artificial channels are not a significant water body, but you will find that most of them take from a significant water body.
Yeah.
Most of them discharge into a significant water body. And we all know where all those significant water bodies end up, which is Wairarapa Moana, which should be the jewel in the Wairarapa crown.
They have their own ecosystem.
Yeah, we can only have questions, sorry, Commissioner.
Does that, does including them potentially mean that the rules around our water races could expand beyond what their initial use was for, and therefore the regulations around them?
Am I allowed to ask a point of clarification? Are you talking district plan rules or separate council bylaw rules?
Yeah, well, I think they're probably linked, I think, somehow, because the water races themselves, well, I know our two in South Wairarapa have specific acts of parliament on them. How does this plan interact with those management acts of those water races?
If you have a look at the appendix 1, as I've noticed, to my summary statement, I'm noting that most of them are in relation to setbacks. I'm also aware that there is particularly different rules, given that the Maroa race in Greytown also goes through the urban area and forms part of the stormwater
At present, which is highly contested, well, controversial as well for the farmers where that is discharged onto their land. So it's a very moving feast at the moment. And by defining it or bringing it into here, my question is that going to cause problems, unforeseen problems down the track, I suppose, for a better term?
From a planning point of view, it hasn't caused unforeseen problems having setbacks from water races.
No, but I'm not so worried about the setbacks and things, but by bringing, I suppose it's the law of unintended consequences. We bring something into a plan, and therefore we've got an act of parliament with regards to the water races. We've got into a plan, and then does that give? And then, as Jeppy identified, the development of those things over 100 years creates an ecosystem. That's right. Therefore, the life of this thing gains a life of its own beyond what the original intent of this waterway may well have been, and therefore we end up with a whole lot of issues that we can't then go back to what it was originally designed for. I suppose, for example, we've now got this water body, which was designed for stock feed, which we now have to fence off. Do you see how that we're getting sort of creep here of rules and regulations beyond what was potentially foreseen to start with?
Along the district plan.
I'll try and summarise that.
How to word it.
No, I think what Commissioner Plymouth raised is an important point, and it goes to are these provisions the most appropriate provisions to give effect to the policies and objectives? So having regard to alternatives. So there no doubt there'll be rules in the natural resources plan. There'll be these proposed rules, which are in the proposed plan, which are predominantly setback rules. And then there'll be bylaws or statutory controls. And what we need to, in terms of an efficiency and effectiveness argument, we need to understand that these aren't duplications, but they are appropriate with food and what they're seeking to achieve, because we heard earlier from Ms. Treadaway and Mr. Wesley that in relation to provisions that the Greater Wellington are seeking to introduce in relation to a Three Waters chapter, matters that are those officers review better captured by the regional jurisdiction because they largely deal with sediment going into waterways. I'm not clear from the Appendix 1 what the purpose of circled them. There's numerous rules and there's numerous standards we're talking. And it seems that policy 1 and policy 2, perhaps policy 5, are explanation as to why they exist, but it does talk about preserving the special qualities and natural character. And similar effects on the natural character values is what it values in the water body. I'm just not clear what that would achieve over and above what the regional council rules achieve. So I guess I need a little bit of an exercise on what the equivalent rules are in the regional council, what any other bylaw rules are, and the extent to which there is or isn't duplication, and what the overriding purpose of the district plan rules are. Is it an amenity issue or is it a water quality issue? Yeah, that would be useful so that we can make a determination on the appropriateness of these rules. Is that fair?
Yeah, Nathan, it's probably way better than I put it.
I mean, that's just... Anything else on the surface water body? Surface, no. Water body provision definition. Was there anything else that you wanted to?
Yes, the other matter was a result of the Eastleigh legal mission. Initially, when I did my 42 report, I was not recommending making the changes. However, you read their legal submission, and I do believe that they make an incredibly valid point about documents changing over time. So I have amended my recommendation that we delete and references the higher order documents. I'm just going to my exact wording of what I have mentioned in this page, but I have noted that I would like that to not apply to the national planning standards, because I think it's useful for a context and clarity in the plan to know where it's a national planning standard and couldn't be changed. But I am recommending that we remove references to source documents in the definitions chapter insofar as the national planning standard definition be excluded from this amendment.
Could we see that in the terms of a struck out or track change revision?
It was what I had printed off all ready to go there, but it didn't actually strike them out. but I can give you a copy of that to do a comparison, and we can email the struck out.
Yes.
Um,
And I wondered whether you might be able today to circulate that to Eastleigh.
Certainly.
If Mr. Foster, I don't know if Mr. Marshall, Joshua Marshall, I don't know whether he was planning with him. Right. Thursday, sorry.
So can I just clarify, what are you saying, Sals? Are you saying that by removing the reference to the source document, if the higher document changes, it won't change our definition?
It doesn't change the definition that it's set at the time of the notification. So and we know, for example, there is some national policy statements that are being reviewed right now. So if we had an example, if we use one of the electricity ones, I'll jump onto my hard copy of it, but it says that this definition is taken from the national policy statement for electricity transmission. If that national policy statement then goes and changes, and that definition changes, we may have a definition that's inconsistent with that, where if you remove that source document, we can still have this definition, and if it's inconsistent, it's inconsistent, but it is a definition that is in the combined district plan, and then we can amend at a later date.
For scheduled process.
Yes.
That's the important thing. That these terms and definitions are, to want of a better term, time stamped to the plan as notified and finalised. And if there's any change out of fairness, that change will go through a process.
Makes perfect sense.
I'm interested though in your exception to that in terms of national planning standards. Why would you draw a distinction with those? Why if there was a change to a particular definition in the national planning standard, would a force of regulation make that change automatically to all district plans, or would it also have to go through a first schedule process?
I was unclear of that.
Okay.
As to whether a national planning standard would supersede it or not, or whether it would be set at that same time. We can seek some advice on that.
What was the direction of the national planning standards when they came out? Was there a timeframe in which the council had to give effect to standardising their formats and terms in relation to the national planning standard? Or was it at the time of the next review of the plan?
I believe there was both. I think there was a combination of both.
Okay.
And within our plan, 45 of the definitions are national planning standards. So I was of the opinion that if that got a significant overhaul with the definitions, if there's 45 that were affected, and we did have to go through a plan change, it could be quite a nuanced plan change if we had to. That was part of my reason of keeping them in.
Could I just ask you to reflect on that? Particularly if there were some unintended consequences where you relied on a definition and the NPS, that definition changes and it has a consequence that wasn't anticipated and better dealt with through a federal process. Because the solution might be any regulation that the government puts down in relation to how those NPS new definitions might be dealt with. I certainly want to pre-anticipate that.
I have also flagged in my summary statement about with the Eastleigh legal submissioners, I was unclear whether it was just the main references to the national policy statements, the national environmental standards, or whether it was also covering the national planning standards. So
yes,
they may have a view on that as well.
Yes, well, I think Eastleigh having a copy of your updated summary statement might be of assistance, and it might speed things up on Thursday when Ms. Foster attends.
Yes.
Any more?
I just so my question that I put to Mr. Weasley around where was Marion Community Facility, I found the reference to community facility and fire and immediately content of section 125 of this report, whereby proposed change. That's community facility maintained and buildings used by members of the community for recreation, sporting, cultural safety, so cultural. And then it's also mentioned in the recommendations on page 24. Recommended amendments to definition. That's just a heads up of where I found it
Yes,
for the reference for him.
and FENS wasn't proposing to change the first part of that definition, were they?
No.
Okay.
I'm right. Thank you.
Triana? Just checking, Alistair?
No, good, thanks.
Craig? Thanks, unless there's anything else that you have for add, thanks. Great. Thank you, everyone. At 12:33, we've made tremendous progress.
We have.
Appreciate your attention to detail. We're under a little bit of pressure for thinking on the who. So, but as I said, is that opportunity to formalise your response in the letter.
Yeah.
Is there anything, I'm looking at you, Hamish, is there anything that's unclear in terms of the matters that we've directed for future?
Yes, we do. It's on Thursday. At the end of the day, have a table with you a list of the matters.
That would be really useful. Yeah, as an inventory to tick off and add to presumably.
Thursday.
Yes. Thank you all. On that basis, I adjourn the hearing until 9 AM on Thursday. Thank you, everyone.
Thank you.
Oh, last time.
Yes.